be agreed to. I'll give the call to the member for Melbourne Ports.
Thank you very much, Acting Speaker. As the member for Blair said when speaking on this appropriations debate, he was going to speak widely and wisely. I'm going to reflect on some expenditure in areas that I don't say was deliberately misspent, but I don't think these monies were spent wisely by the Australian Federal Police, by the Department of Finance, by the courts. Some of the things I'm going to say will be unpopular, particularly with members of the government, but they have to be said. In the ACT Supreme Court on the 25th of February, Judge John Burns exonerated the former Speaker of this Parliament. He said, quite rightly, that having lunch with staff could be considered parliamentary duties. The definition was so wide. The failure to apply to former Speaker Slipper the Minchin protocols by which all of us in this place are able to repay taxi fares or travel expenses that are undertaken mistakenly or not properly noted is something that led to a whole series of misallocation of resources, including Slipper's prosecution by the Commonwealth Director of Public Prosecutions over this $954, which cost him more than $150,000 personally, his reputation, his marriage, his life, his mental health, and the Commonwealth, in its various manifestations, at least $400,000 to $500,000 to get one member's taxi receipts. Was this a wise expenditure of public money? When Peter Slipper accepted the speakership, he did so insisting that it was he would not be party to maintaining Labor in office. He felt that the Labor government was going to stay in office whether he accepted the speakership or not. Slipper being made Speaker, of course, made it a little easier for Labor on the floor of the House, but the Labor government was able to survive with Mr Jenkins as Speaker before Slipper and with Ms Burke after Slipper. He was a very good Speaker. I remember, to the surprise of the coalition, he sat then Treasurer Wayne Swan down in his seat, and the praise for him in the media at the time as a person who knew procedure and the rules. There was an article by Jeff Kitney in the Financial Review, which is a sort of typical of this process. Also related to this misspending, in my view, of public monies was the Federal Court's refusal on the 9th of February 2015 for Mr Ashby's applications for costs in this case. These costs are estimated at $3 million. The Federal Court added the Commonwealth costs to Ashby's costs and his lawyer's costs. The Federal Court's judgment made clear Ashby's sexual harassment claims were never vindicated, as he claimed subsequent to the RERA's judgment being invalidated by the Federal Court. When Ashby withdrew the sexual harassment case on June 14, he stated he believed the Federal Court's decision to grant an appeal had indirectly suggested harassment had in fact occurred. The Federal Court judgment makes it explicitly clear that that was not the case. The final paragraph of its finding says, "But for the discontinuance of his claim, Ashby may well have been tested about why the primary proceeding was instituted in terms it first appeared, and on a range of matters raised by Slipper arising from his summary dismissal application and defence claim." It's true in the Federal Court made a 2-to-1 decision to overturn RERA's, giving Ashby the benefit of the doubt. Procedural fairness. They wanted to let him proceed with this case, even though RERA's had made a very strong judgment against him. Remember, these allegations, Acting Speaker, were allegations that transfixed Australia. They led to 12 front pages of the Daily Telegraph, including the former Speaker being portrayed as a rat with drawings all around him. 12 front pages. Lady Di only got 9. Judge Reras, who examined the case most comprehensively, said it was an abusive process. The judge skewered Mr Ashby's solicitors harmers for a strategy that was designed, quote, to expose the Speaker to the maximum degree of vilification, opprobrium, sensation, scandal, cause a maximum damage to his reputation for the political benefit of the Liberal National Party and his opponent in the electorate, Mr Brough. Of course, Harmers are an important solicitor, and an important solicitor for all of us members of Parliament to remember, because what could happen to Slipper could happen to any of us. That they could use sensational public allegations by legal firms on a no-fee, no-pay basis to make sensational allegations, as they did in the DJ's case, probably the reason why they were brought into this case against Slipper. This is a very dangerous precedent, a slippery slope, Speaker, that legal firms interfering in the political process like this could, as I say, happen to any of us and to people more popular than the then Speaker. Reres found the claim made by Ashby was an abusive process. Ashby's predominant purpose, Judge Reres said, for bringing these proceedings was to pursue a political attack against Slipper and not to vindicate any legal claim he may have for which the right to bring proceedings exists. He stole his employer's diary. I wonder if Mr Katter would like one of his staff to have his diary stolen and given to the Daily Telegraph. It's an absolute unethical thing for any employee to do. To introduce, as the judge said, 2003 allegations about a sexual relationship and assertions about cab charges for no legitimate forensic purpose, the judge said. They were not included in the originating application to advance any bona fide cause of action that Ashby had against the Commonwealth or Slipper. The effect of their inclusion, and I find the purpose, was to damage further Mr Slipper's regard in the public eye and politically, and to attract him significant adverse publicity. After dropping his allegations in mid-year, Ashby appeared on 60 Minutes. It was recently re-shown in January. On that program, he claims to have been induced by Liberal MPs, prominent members of the government now, into making his sordid claims. What he told 60 Minutes was that these inducements, what he told about these alleged inducements directly contradicts what he put on oath in a sworn affidavit to the justices who overturned in a 2-1 judgment Reres's judgment. I wonder if the judges had seen what he said on 60 Minutes, whether they would have indeed overturned Reres's forensic view of Ashby's activities. I'm sure they wouldn't have. Accordingly, after the program, I wrote to the Commonwealth Director of Public Prosecutions inviting him to investigate whether perjury had occurred and that the appeal judges were misled by the affidavit. At the very least, his claim of inducements made on national television twice now, in July and January, should have been available to the appeal judges when they reviewed Reres's judgment. So perhaps millions of dollars spent chasing Slipper's $900 taxi fares, the millions of dollars spent by the Department of Finance and in the courts might never have had to have been contemplated if we would have known in the beginning that these cab charge fares, which were silly to go beyond the boundaries of Canberra for lunch with staff, but were still ultimately found by a judge to be possibly parliamentary business. And if we would have known that, as Mr Ashby now claims on television, that he was offered inducements, the judgment of Judge Reres would have been clearly vindicated. I'm reluctant to believe anything that Ashby says, even if it's politically convenient from my side of politics or me personally to believe. If he told the truth, however, to 60 Minutes, there's a powerful message to all MPs from this. The politics of personal destruction, even for a member as unpopular as Peter Slipper, that was engineered by the member for Warringah and the member for Sturt and carried through with these obscenely expensive royal commissions that they have now into Prime Ministers Rudd and Gillard, have no proper place in Australian public life. The admission from the existing member for Mr Slipper's seat, Mr Brough, on 60 Minutes, that he had directed A G. Gordon Liddy-style Black Ops misappropriation of the Speaker's confidential diary is one that the Prime Minister has already reasons to carefully consider. The old warning, be careful what you become in pursuit of what you want, should be ringing in the ears of members of the government after this disturbing 60 Minutes broadcast. I witnessed, Speaker, and I want to record this for Hansard, on a daily basis in the months February, March and April 2012, what appeared to me when I went into the Speaker's office an entirely professional relationship between him and his constituent adviser. Strangely, excluded from the 60 Minutes program was Extra Minutes, a special that they put on online. And in that Extra Minutes, it's very odd that Mr Ashby, who claims to have been repulsed by the Speaker's approaches, made it clear that the last straw for him in his betrayal of his employer was that the then Speaker would not take him on a first-class trip to Hungary. As David Marr argued in The Guardian, a few days later, under Bruff's direction, Ashby began scouring Slipper's office for damaging details of travel expenses to be fed to the Telegraph journalist Steve Lewis. I won't go into all of the details, as I was, about the role of the Murdoch press in all of this, the Daily Telegraph, the securing of him in a safe house in Sydney. I just want to conclude with some of the points about how this was used for the destruction of the Gillard government and at the terrible destruction of one individual. Slipper was a competent speaker. Slipper is an eccentric character. Slipper probably said stupid things, sexist things to his staff member. The texts, let's all remember this, the texts that were introduced into this parliament by the member for Curtin were made between Ashby and Slipper 2 years, Mr Speaker, before Ashby was in his employment. What would any of us think of a person who was a prospective employee of ours, who recorded our conversations with a possible view to blackmail, texts, personal texts between us? You inveigle yourself, you try and become popular with a person, and I know the case of Slipper. He married a younger woman, Inga, a lovely person, who convinced the then Speaker to take a more modern view of a gay man, Ashby. They took them into their bosom, they took them into their office, and their confidence and their trust were abused in the most foul way. I saw that man in his office all the time, working happily with the Speaker, and only when his overseas trips or the prospect of bringing down the government and vast amounts of cash suggested to him that he could have another course did he betray the couple that looked after him so well. And there are other people who have guilt in this role too. The former Attorney-General, my friend Nicola Roxon, should never have made a different standard for the then Speaker that had been made for all leading members of this parliament. He should have had a legal defence. Now we all have insurance to protect ourselves, each of us, from an employee doing a similar thing to us. And that's justified. And the former Special Minister for State is an excellent person who foresaw this problem, not just for Labor, but for all sides of politics, and introduced these insurance schemes. It was also dishonourable that his solicitors, the firm of Morris Blackburn, abandoned Slipper on the edge of court after the Commonwealth unwisely made its separate deal with Ashby for $50,000. A deal which, if it would have waited, Judge Reras would have invalidated. The cab charge thing has been invalidated in the Canberra court, and we would have now known via 60 Minutes that this was all done because of prospective inducements. Acting Speaker, some people affectionately refer to me as the member for lost causes in this parliament because of my support for Tibet and Darfur and various other groups that sort of seem to be the Baha'is. I never imagined that I would become a friend or defender of a National Party member from Queensland. But this is not over, Mr Speaker, because if the CDPP recommends that after advice from the federal police, that these inducements be looked at, this is not
for
over.
his contribution. The question is that